Hi, good day. My name is Hannah Haron, and my hobbies po ay manood ng anime or K-drama. Currently, if my spare time po, I binge watch One Piece. So, I was assigned po to report some parts of chapter 3. So, in partnership dissolution po, sometimes the decision is made to close the business, sometimes there is a bankruptcy, partner negligence, retirement, death, poor cash flow, and change in business practices are just some of the reasons for closing down po. In most dissolutions of a partnership, yung mga business partners, kailangan nila mag-decide kung ano yung gagawin or mangyayari sa partnership mismo. A partnership may be dissolved, but that may not end business operations. Kung i-continue man po yung partnership's business operation, kailangan po mag-decide ng partnership kung ano yung gagawin sa mga customers or clients, particularly po to those primarily served by a partner leaving the business. So, sa first topic ko po, is the agreement of the partners affecting liquidation valid? The liquidation of the assets of the partnership following its dissolution is governed by various provisions of the Civil Code. However, an agreement of the partners, like any other contract, is binding among them and normally takes precedence to the extent applicable over the Code's general provision. So, over a period of time po, the partnership's non-cash assets are converted to cash, creditors are paid to the extent possible, and remaining funds, if any, are distributed to the partners. Before proceeding with liquidation po, the partnership should complete the accounting cycle for its financial operation period. This will require closing the books po with only balance sheet accounts remaining. Once po na na-complete yung process, four steps remain in the accounting for the liquidation po, each requiring an accounting entry. So, these steps are, step 1, sell non-cash assets for cash and recognize a gain or loss in realization. So, realization is the sale of non-cash assets for cash. Step 2, allocate the gain or loss from realization to the partners based on their income ratios. Step 3, pay partnership liabilities in cash. And step 4, distribute any remaining cash to the partners on the basis of their capital balances. So, yung mga steps na to, kailangan po i-perform in sequence. Partnerships must pay creditors prior to distributing funds to partners. Next, what is the meaning of retirement in dissolution? So the term retirement in a generic sense means the dissociation by a partner, inclusive of resignation or withdrawal from the partnership that thereby dissolves it. So, retirement of a partnership from a business po is not equivalent to the dissolution of the business. Though if one partner retires po sa partnership consisting of two partners, it shall amount to dissolution of the business. But when a partner retires from a partnership consisting of more than two partners, the partnership is not automatically dissolved po. Siguro na-mention naman na sa first reporter ng chapter 3 about dissolution na hindi siya automatically terminated or the operation will be discontinued. Kasi nga yung dissolution does not necessarily terminates the basic business operation po. Meaning, pwede pa rin mag-proceed sa partnership sa operation kahit pa magkaroon ng dissolution. It is under Article 1829 po. So, yung example po sa book, X was formerly the Assistant General Manager of the marble quarrying and export business with the firm name of Mountain. The partnership was originally organized with L and R as general partners and A, B, and C as limited partners. X actually received only half of his stipulated monthly salary since he had accepted the promise of the partners that the balance would be paid when the firm shall have secured additional operating funds from abroad. X actually managed the operations and finances of the business. Without the knowledge of X, L and R sold their interest in the partnership to W and Z. C, a limited partner, also sold his interest in the partnership to W. The partnership now constituted sold by W and Z, who continued to use the old firm name of Mountain. All the employees of the partnership continued working in the business, all save or except X. Subsequently, X was informed by W that the latter had bought the business from the original partners and that it was for him to decide whether or not he was responsible for the obligation of the old partnership, including X unpaid salaries. X was in fact not allowed to work anymore in the mountain business enterprise. His unpaid salaries remained unpaid. Consequently, X filed a complaint for recovery of unpaid salaries against Mountain and W. The partnership and W denied X charges, contending in the main that X was never hired as an employee by the present partnership. So the question uh, was the partnership which had hired X extinguished and replaced by a new partnership composed of W and Z? If indeed a new partnership had come into existence, can X nonetheless assert his rights under his employment contract as against the new partnership? So, to answer the questions, it is actually the legal effect of the changes in membership of the partnership that was the dissolution of the old partnership. It is under Article 1828 about dissolution and Article 1830, which I will explain later on, that must also be noted. So, lahat po kasi ng partners dun sa problem sold their partnership interest amounting 82% of the total partnership to the new partners W and Z. Kaso, hindi po napakita sa record yung natitirang partnership interest which is 18%. Yung accusation of 82% of the partnership interest by new partners kasama yung retirement or withdrawal ng partners was enough na po to constitute a new partnership. So, kaso sa issue, hindi na-apply yung Article 1829 which says that on dissolution, hindi siya automatically terminated. So, kailangan muna i-complete yung pag-settle ng business or partnership affairs. Yung business po kasi was simply continued by the new partners. However, the old partnership did not undergo the procedures po of dissolution and winding up ng business affairs. So, being said na tinuloy lang ng new partners yung business, kaya yung new partners, they are also liable sa winding up ng business, particularly dun sa debts ng preceding or old partnership.